Hello, I'm Joel Chorny. I'm a criminal defense attorney here in Tucson, Arizona. And today, what I want to do is I want to go through common terms and phrases that get thrown around pretty regularly in courts here in Arizona, particularly in Pima County, which is where I'm most familiar. But these are terms that are well used, well known in Arizona in the criminal system that I found that people can often mistake. So the plan for today is that I'm going to run through different terms, explain what they are and how they come into play in the system, and then hopefully give you clarity to what these terms mean so that if you ever encounter them, hopefully not with your own criminal case, but if you find that these words come up, you'll understand what they mean and how they differ from each other. And the plan is that we're going to go in sort of an order of the life of a case. So we're going to start with the beginning of a case before charges are filed up to the point where charges are filed and how they're filed. Then we're going to talk about what happens when the case is already underway, but before we get to a trial. Then we're going to talk about the trial process and some of the terminology that we commonly see or that are regularly parts of a trial. Then we're going to talk about sentencing and after sentencing and the terms that we have there. So that's the plan. So starting with the beginning of a case. Before there's a case, there's an investigation, and an investigation can be prompted either by an impromptu police contact. A police officer sees something happening and they go and they stop the person and inquire further, or they can apply for permission to go into a person's home or place of work or to go and arrest the person based off of information that they've gathered. That application is usually for an order called a warrant. So that's our first term for today. What is a warrant? A warrant is a document that needs to be supported by articulable facts that lead to the conclusion that law enforcement, that the government has what's called probable cause to go into someone's private space and either search that space looking for evidence of criminality or arrest a person. So there are two kinds of warrants. There are arrest warrants and there are search warrants. Arrest warrants are what they sound like. They are an order to go and seize the person of a person, whereas a search warrant is an order allowing law enforcement to enter a space that they otherwise would not be allowed to enter into in order to seek evidence of criminality. And these warrants need to be supported by specific articulable facts that describe the place that is to be searched and the reason, what it is that they suspect that they will find there and why they suspect that. Police are not allowed to lie on warrant applications, although they often do, and that's something that criminal defense attorneys do help deal with. But generally, what they have to do is they have to reach out to a judge, explain to the judge what it is that they're investigating, who it is that they're investigating, and what information they've gathered so far, and why they think that they're going to find additional evidence to support their case in whatever space they are seeking to search. And that's what a warrant is. Now, you might also hear the term bench warrant. A bench warrant is very similar, except it's a warrant that's issued from the bench. It's something that a judge will issue pretty much on their own initiative to go and arrest a person who generally has not shown up to court like they're supposed to. So if a person is out, say, on bond, they're facing criminal charges and they are released on a bond and they don't show up. First of all, the bond can be forfeited. I'll talk about what a bond is in a second. But more importantly, the judge can order law enforcement to go and bring that person in. And that's what's called a bench warrant. And you might hear people talking about getting a warrant quashed. Usually it's a bench warrant we're talking about getting quashed, meaning that the subject of the warrant, the person that the police are going to go arrest, when we find out that a warrant has been issued for them, we file an application with the court to cancel the warrant, to quash the warrant, not squash it. I've heard people use the phrase squash a warrant, which is evocative and illustrative, but wrong. It's to quash a warrant. And so that's what that's about. Now, what is an arrest? An arrest is a detention of a person that has to be supported by probable cause, and then that's it, basically. So an arrest can be done very formally, where a police officer says, you are under arrest, and they put handcuffs on you, they put you in the back of a squad car, they take you to jail, they book you. That's what most people think of as an arrest. But an arrest can also happen in what's called a de facto arrest, an arrest that's by circumstances. So depending on the level of government intrusion on a person's freedom to move, it could rise to the level of being an arrest. And again, that has to be supported by probable cause. Probable cause being the standard of proof that law enforcement has to have to support the intrusion on a person's freedom to move. Probable cause basically is a fair possibility, fair probability that a person has engaged in criminal conduct if this is for an arrest. And if it's for a search, like in a search warrant, then it would be a fair probability that a search of the space, the premises that the police are trying to search, is actually going to yield evidence of the crime that they are investigating. And so that's what an arrest is. Now, let me talk about a distinction between jail and prison. Since we are talking about going to jail, let me explain what those two things are because people get them confused all the time. Jail is where people get taken when they are arrested but have not yet been convicted, or it is a space where people can be sent to as a sentence for misdemeanor offenses, not necessarily felony offenses, or where a person goes as a condition of probation. So if a person receives probation, and I'll talk about what probation is a little bit later, but as a condition of probation, a judge could still order a person to do jail time. There is no way to do prison time while on probation. Similarly, there's no way to serve probation while in prison. So jail is the institution that can be in play at the same time as probation. But the biggest distinction between jail and prison, the easiest way to think of the difference is that prison is where people get sent after they've been convicted of felonies. You can't go to prison for a misdemeanor. So if you've been convicted of a felony and you are sentenced to incarceration, you are sentenced to incarceration generally in prison. And also generally, we're talking about sentences that tend to exceed 1 year. Although it is possible to be sentenced to prison for less than a year, most of the time people are receiving sentences in excess of a year because for misdemeanors, you're usually seeing incarceration that is for less than a year. Actually, for class 1 misdemeanors, the lowest level of misdemeanor, the maximum sentence is 6 months in jail. So you might be seeing people getting sentences that are between 6 months and a year that are getting sent to prison. Now, it is possible to spend more time than that in jail for various reasons. If you have multiple cases, they're sentenced consecutively, meaning one after the other. There are ways to end up in jail longer than a year, but generally speaking, you're not supposed to be. If a sentence is going to be longer than a year, it tends to be a sentence that is in prison. So it's one of my pet peeves when people ask me, am I going to go to jail over this? And we're talking about mandatory prison time. And so I always correct them and say, you are going to go to prison if you get convicted of this offense because there's mandatory prison time. But that's the difference. So people get it wrong all the time. I've heard judges get it wrong all the time. But that is, in fact, the difference. Jail is generally for people who have not yet been convicted, who are still presumed innocent, but are being detained while their case is pending. And prison is only for people who have now been sentenced to prison. The next term I want to talk about is IA, or initial appearance. So in Arizona, when a person is arrested, let me back up, not just in Arizona. Federally speaking, a person has a right to appear before a judge after they've been arrested and detained within 48 hours of their arrest. However, in Arizona, we are better than that. We tend to have people appear in front of a judge within 24 hours. And in fact, in Pima County, we're even better than that. We have two different IA calendars every day. And because we have two IA calendars, one in the morning and one in the evening, people are seeing judges basically within 12 hours of their arrest, which is not great for the person who's detained, but it's pretty good in the scheme of how things work throughout the country. And the initial appearance is when the person will show up in front of the judge, and the judge will explain what the person is being held on, what their charges are. The judge will consider the person's characteristics in terms of their criminal record, what the nature of the offense is. They'll have a very brief synopsis of the case, of the information that led to the arrest of the person, and the judge has to first determine whether or not in what's called the four corners of the document of the complaint, which I will explain in a second what that is, whether or not the police are describing a crime with enough detail that the judge could say that based on this description, the police do in fact have probable cause to believe that this person committed this offense. And if the judge at the initial appearance does not find that there is probable cause within the four corners of the document, then the judge dismisses the case. without prejudice, meaning that the state could refile the charges later, but that the person is going to be released on that matter. If the judge does determine that there's probable cause, well, then the case proceeds, and the judge will then set conditions of release. These conditions of release can be as light as you better promise to come back to court, Mr. or Mrs. Defendant, and that's what's called being released on one's own recognizance, or it could get all the way up to we are holding you on some amount of bond. And generally, the more the judge thinks that the person is a risk of flight, meaning that they're not going to come back to court as they're required to, the higher the bond will be. Now, here in Arizona, we have law that says that the judges are not supposed to be using bond as a way of making sure to keep the person in custody as a way of protecting the community. Now, I will tell you, I see judges violate that all the time, where the judges get really shocked by the nature of the crime. And so they will set a very high bond, even though there's not much indication that the defendant wouldn't show up to court based just off of their promise to appear, or by that intermediary level of supervision, which I have not yet mentioned, which is pretrial services supervision. So there is an agency called pretrial services that is an arm of the court that is tasked with supervising people who are on release while their case is pending. So instead of holding them in jail where they cannot earn money or provide for their families, the court can release them to the supervision of pretrial services so that they can remain in the community, keep working, keep providing for their family, and come to their court dates and face their case. And that's what's called pretrial services supervision. And there are different levels of that. There is more enhanced, higher levels of supervision. There is ankle monitoring that can be done where a person has to pay to actually put an electronic GPS ankle monitor on themselves so that the pretrial services people can know where they are at any given minute of the day. They can have orders to not return to certain locations, to not have contact with certain people, to not possess certain things. It is very common for people who are facing charges to be ordered to not consume or possess any alcohol while their case is pending. Depending on the nature of the offense, domestic violence being the most obvious example, they might be ordered to not have possession of any firearms while their case is pending, etc. And they are also ordered to make sure that they show up to their court as is required. And that's what pretrial services is. And all of this is determined at the initial appearance. Now, I mentioned previously a complaint. A complaint is a document that the police will file that will describe somewhat briefly the offense that they are accusing the person of, that they're charging the person of, and some narrative of how this person came to be arrested. And that's called a complaint. Now, you might also see a document labeled interim complaint. So a complaint is generally what is used to charge a person with a misdemeanor, with an offense that at most could have 6 months in jail. And an interim complaint is similar, except that it is for felony charges. And the reason it's called an interim complaint is because when a person is charged with a felony, meaning an offense that could carry prison time and could carry a sentence in excess of 6 months, in excess of 1 year even, then there's an expectation that the prosecuting agency, either the county attorney or the attorney general, will have to seek what's called an indictment. And I'll explain what an indictment is in a moment. But that indictment is another probable cause determination. So I mentioned that at the initial appearance, the judge is determining whether or not there's probable cause within the four corners of the complaint. And so we're talking about a felony, it would be within the four corners of an interim complaint. But that probable cause determination is not going to be enough for the case to go all the way to the end. The prosecutor is going to have to seek an additional determination of probable cause, either through what's called a preliminary hearing or by going to the grand jury and seeking an indictment. And I'll explain what that is in just a moment. But the reason it's called an interim complaint is because it's understood that some other document is coming. And if the prosecution does obtain an indictment, which is the more formal charges that comes after the determination of probable cause, that subsequent determination of probable cause, then what will be issued is what's called a notice of supervening indictment. It's supervening because it is now going on top of the interim complaint. Whereas if a prosecuting agency chose to charge someone with a felony without arresting them ahead of time, which is something that can be done, they can go to the grand jury and seek an indictment. And if the grand jury issues an indictment when there hasn't been a previous arrest, an initial appearance where that first probable cause determination was made, that would be called a direct indictment instead of a supervening indictment. It's just talking about the relationship between how the charges are being created. So, an indictment is a document that has the formal these are the charges in a felony case against the accused. And this is something that a grand jury determines or that a judge issues after a preliminary hearing. And so what happens is that at the initial appearance, among setting the conditions of release that I just mentioned, the judge is also going to set another court date, a preliminary hearing date in felony cases. That preliminary hearing date is called preliminary because it's supposed to be the first hearing. And it is where the state has to show a judge that there is, in fact, probable cause to proceed with the case, that there is a fair probability that the accused committed the crimes that they are being charged with. That looks a lot like a trial. To the uninitiated, if they were to watch a preliminary hearing, they would say this is a trial. And it's similar in that this prosecution or the state is there. They are the ones seeking the probable cause determination. There's a judge that presides over the process, and the defendant and his attorney or her attorney get to be present as well and argue against what the state is seeking. Generally, at least here in Pima County, we don't see a whole lot of preliminary hearings. The prosecutors tend to prefer to go and present their case to the grand jury, and that's for several reasons. The grand jury presentment is done behind closed doors in secret. The defense does not generally get to participate, and so the defense doesn't get to find out how the grand jury process went until after the fact. And so it's a lot easier for the state to obtain that probable cause determination if they don't have a pesky defense attorney getting in their way. And they tend to prefer that. The other reason they tend to prefer that is because they can control the narrative more cleanly and keep things from becoming known or public until later. So they can present just the minimum information that they need to get their charges to stick, and they can hold on to information. So for all of those reasons, they would much rather present the case to the grand jury and get an indictment from them. So once the indictment is issued, the next term I want to talk about is the arraignment. Now, the arraignment is a hearing that a defendant is required to appear at, unless it's misdemeanor court, in which case often the attorney can appear on behalf of the defendant. But if we're talking just about felony court, then there is an expectation that the defendant is going to appear at the arraignment. And the arraignment, it's kind of a holdover from olden times. Frankly, in practical terms, it's not a very important hearing. Not a lot gets learned at that hearing. Certainly nothing that couldn't be sent out as a communication in writing to the parties. But as I said, it's a holdover from olden times when people were brought up to the court and presented with the charges against them. They were arraigned, and we still have that to this day. In most practical terms, the biggest impact of the arraignment is that it's what starts the clock for speedy trial time. And I'll talk about what that is in a moment. But it's really the official beginning of the case. Once the person has been arraigned, then the prosecution's duty to make disclosure of the evidence that they have in their possession to the defense gets triggered. Before the arraignment, they don't have to provide any information to the defense. And so that is a very big impact of the arraignment. But what happens at the arraignment is that the defendant presents themselves before the court. If they're in custody, at least here in Pima County, it's usually done by video. If they're out of custody, they'll actually come to the Superior Court to present themselves. And the judge will ask them if their name is spelled correctly on the indictment. And if it is, they will confirm that. If it isn't, they'll explain what's the mistake and it will be corrected. They will be told the name of their attorney. If they have received court-appointed counsel, they'll be told the name of their court-appointed counsel, or at least the agency that the attorney works in. If they've retained counsel and the attorney that they hired has already put in what's called their notice of appearance, notifying everyone that they are on the case, then that information will be shared with the defendant just to confirm that the court is aware of who their lawyer is. They'll also be told the name of the judge assigned to their case. And that's really important because not all judges are equal. Different judges have different personalities and different takes on different things. And so there is an option to do what's called striking the judge under Rule 10.2 of the Arizona Rules of Criminal Procedure. And that's something that you only have 10 days to do from the date of arraignment. Again, the clock starts with the arraignment. So in addition to learning the name of the judge assigned to the case, and so that you can decide whether or not you want to exercise your right to strike that one judge, you also will receive here in Pima County 2 additional court dates, your case management conference and your pretrial conference. The case management conference comes a month later. The pretrial conference comes 2 months later. And I'll talk about what that is momentarily. So that's the initiation of the case. That's the beginning phase. Now that we're going to move on to the phase of the case that I call the before trial phase, but we are well underway with this case at that point. So between the arraignment and the case management conference, we start seeing the state provide disclosure to the defense. They send over the police reports. Ideally, they start sending over the recordings, body cam footage, 911 calls, witness statements, things like that, photographs that they may have, surveillance videos. Generally, between the arraignment and the case management conference, they don't have the forensics results yet, fingerprints, DNA, things like that, because it takes a while to process those things. But once they do have those items, they're supposed to provide them to the defense as well. And then we get to the case management conference, which, as I mentioned, is a month after the arraignment generally. The case management conference is just the first regularly scheduled hearing in front of the assigned judge. It's just that first built-in moment for the parties to come together in front of the assigned judge and let the judge know how things are going. Generally, at the case management conference, things are just getting up and running. And so it is most common to tell the judge at the case management conference that there's still pending disclosure, or that there's ongoing negotiations, or that there's further investigation that's happening. And you simply affirm, meaning you confirm, that the pretrial conference date is set and that you'll see everyone will be seeing each other again at the pretrial conference about a month later. Now, the pretrial conference is very similar to the case management conference, except at least here in Pima County, it's labeled as such to create a distinction between the first hearing that is regularly scheduled with the judge and the second one. The expectation is that at the pretrial conference, one of two things is going to be happening. Either you're going to be setting a trial date, or the defendant's going to be taking a plea or pleading guilty, changing their plea from not guilty to guilty, because every criminal case starts with a not guilty plea. People are presumed innocent. The state has to prove their guilt beyond a reasonable doubt. And so for the case to progress, it has to be understood that the defendant is pleading not guilty in order to require the state to meet its burden of proof. The moment a defendant pleads guilty and admits the guilt, the case ends. I mean, there needs to be sentencing subsequent to that, but that's basically the end of the case. And so at the pretrial conference, that is an opportunity for the defendant to change their plea from not guilty to guilty. However, it is very common that you get to that second court date, what is labeled as a pretrial conference, and you're still not ready to do either of those things, either because there's still pending disclosure, there's still pending plea negotiations, or there's still pending investigation. And so it's quite common to get to that pretrial conference and to explain to the judge that more time is needed. And the judge has options. The judge can set the next hearing as a continued pretrial conference in order for it to still be understood that the expectation is that a trial date is going to be set at that next hearing, or that the defendant's going to have by that date to decide on whether or not they're going to be changing their plea from not guilty to guilty. But the judge could also set the next hearing as what's called a status conference, and that's the next term I want to define. A status conference is just a generic hearing. It could be for anything. It's basically the default name for a hearing that is not meant to convey exactly what's happening at the status conference. It's just the generic, hey, we're going to have a conference to see where things stand. And that's what's called a status conference. And so it's really up to the judge if they want to set a hearing as a pretrial conference or as a status conference. It has a lot to do with how they manage their calendar. If they're concerned about having a bunch of changes of plea, which can take a while on their calendar, they might want to make sure that they're keeping track of how many pretrial conferences they have on their calendar so that they don't end up in a situation where they have more people prepared to plead guilty and go through what's called a plea colloquy, where the judge talks to them about what they're doing, make sure that they're doing it knowingly, intelligently, and voluntarily. And so the judges might simply want to make sure that their calendar properly reflects what they can expect to be doing on any given day, which might be why they choose to have the pretrial conference label instead of saying a status conference. But that's what a status conference is. Now, I've used the phrase disclosure quite a bit. Disclosure is the information that a side has to provide to the other side in a legal case. In the civil world, there is such a thing as disclosure too. And disclosure is governed by rules of either civil procedure or criminal procedure, but also by case law. There are rules that talk about things that the prosecution has to turn over to the defense, such as what's called exculpatory evidence, evidence that helps cut against the notion that the defendant is guilty of what they're being accused of. That's a case called Brady v. Maryland. which is very important. It's a Supreme Court case that says that law enforcement and the state are not allowed to withhold exculpatory information from the defense. And so that and many other things, the state has to turn over to the defense, and that's what's called disclosure. This term is very closely related to discovery. And frankly, I have often switched back and forth between the two. They're understood to be almost the same thing. But the way I understand the difference is that discovery is more of a process. Discovery is the process of getting the disclosure to the right people. And it's a phase of a case. In the civil world, it's very common to talk about how the case is in discovery, meaning that we're still providing the materials to each other, and eventually the case is no longer in discovery; it's now moving into a trial posture. In the criminal side of things, we don't talk about things as being in the discovery phase so much, and so in the criminal arena, we do tend to use disclosure and discovery pretty interchangeably. I mentioned that disclosure is governed by rules. The rule of criminal procedure that governs disclosure is Rule 15. There are rules that talk about what the state has to provide, there are rules that talk about what the defense has to provide, etc. And that's all covered under Rule 15 of the Arizona Rules of Criminal Procedure. The reason I wanted to bring up Rule 15 is because there is a term of art that is used very commonly in my field that is Rule 15s. We need to do Rule 15s. If you're sitting in court, you might hear a lawyer say, Your Honor, we're still trying to schedule the Rule 15s. What that is pretrial interviews of witnesses. I forget which subsection of Rule 15 it is, but there's a subsection of Rule 15 that says that the parties are entitled to have pretrial depositions of witnesses, and that the witnesses need to collaborate and cooperate with providing these depositions. And if they don't, um, you can ask the judge to order them to do so. The thing is, depositions, which are these more formal interviews that are done with a court reporter, someone, a stenographer who's taking down what people are saying, and it's very formal. Both sides have their attorneys there. The witness comes to a prearranged place, the court reporter is there, and then you engage in an interview. They're expensive. You got to pay for the court reporter. You got to line up the space, and they tend to be much more complicated. And so, ideally, you could just interview the person without having to go through all of the rigmarole of a formal deposition. And so, when a witness agrees to be interviewed and does so without you needing to get a court reporter, you have what's called a voluntary pretrial interview instead of a deposition, and we call those Rule 15s, Rule 15 interviews. Frankly, depositions are pretty rare in criminal cases. You can usually get a witness to voluntarily sit down with you to do an interview. Now, the witness is allowed to set parameters as long as they're reasonable. They can require that the prosecution be there for the interview. They can dictate the time and place of the interview within reason. They also can choose to record the interview themselves if they want to. Generally, these interviews are recorded. At least the defense attorney is going to record the interview. Generally, the prosecution does as well. But they still tend to be much more informal than a proper deposition. And so that's what Rule 15s are. And often you'll hear people talking about in court how they're having a hard time scheduling the Rule 15s. And that's what that is. Now let's talk about motions. Motions are requests of the court. When you file a motion, you're asking the court to do something. You're trying to move the court into some kind of action. That's what a motion is. Now, motions are a very particular kind of pleading. A pleading is anything that you file with the court. So you could file a notice just to say to the court, hey, I'm the attorney on this case now. I just want everyone to be aware of that. So that's a notice. You're not asking the court to do anything. You just want it to be clear on the record that you're now the attorney. So it could be a notice, could be a notice of defenses, it could be a notice of a conflict. It could be anything as a notice where you're not actually trying to get the court to do anything, but a notice is still a pleading. A motion, like I said, is also a pleading. It's something you file with the court, and you're asking the court to do something, to make some kind of decision. So it's a motion. One of the most common kinds of motions you'll see in a criminal case is a motion to modify conditions of release, or a motion to modify. And so what that is a request for the court to reconsider the conditions of release that were set at the initial appearance or at the arraignment if the person received a direct indictment and the first time they showed up in court was their arraignment, and then their conditions of release were set there. And so you're asking the court to reconsider those conditions of release and if you're the defense, lessen them. And if the state were to file such a motion, they would be seeking to increase the conditions of release. And so, for example, if a person's been sitting in jail for a couple of weeks, they can't afford the bond that has been set, a defense attorney can file a motion to modify to show the court information that either the court didn't consider at the initial appearance or that they considered but they didn't give proper weight to, and ask the court to reconsider and ideally either lower the bond or release the person to pretrial services. The idea is to try to get the person out of jail. And if it's a matter of the state filing a motion to modify, it's usually because the defendant went and picked up the charges or is having contact with the victim like they're not supposed to. They're not following the conditions of release that the court originally set. And so the state's going to argue that there need to be stronger conditions of release or that the person needs to be incarcerated so that they stop having unlawful contact and doing things that they're not supposed to. And so that's what motions are and what pleadings are. I mentioned when I was talking about arraignments what Rule 8, I said the word Rule 8. What is Rule 8? Rule 8 is one of those rules under the Arizona Rules of Criminal Procedure that dictates the timing of a case. And we generally will mention Rule 8 in court when we're talking about a person's speedy trial rights. In Arizona, a person who is charged with a felony has the right to have their case tried within either 180 days from their arraignment, if they are out of custody, if they're not in jail, or within 150 days of their arraignment, if they are in custody, 5 months from when they've been arraigned. That is a person's right, a defendant's right. And so you'll often hear people talking about waiving time. And when they say they're waiving time, they're waiving Rule 8 time. In other words, they're saying, we're not going to hold the feet of the state to the fire to get the case tried within that Rule 8 time. We're going to go ahead and waive the time between now and the next hearing. So we're going to stop the clock for that period of time so that the deadline by which the trial has to happen gets moved out. And that's what's Rule 8 time. Before a trial, and outside of status conferences, pretrial conferences, and case management conferences, you might see other kinds of hearings. So let's talk about a couple of those. First, let's talk about evidentiary hearings. When you file a motion asking the court to do something, oftentimes the court's going to need to hear more. They're going to need some testimony. They're going to need to look at some evidence. And so they'll set what's called an evidentiary hearing, which is the opportunity to do that. So if you file a motion to, say, suppress evidence, to keep evidence from being used at trial, maybe because the state violated the defendant's Fourth Amendment right against unlawful and warrantless searches and seizures. Maybe they got arrested without probable cause, or they got pulled over without a proper reason. So you would file a motion as the defense attorney arguing that whatever evidence they obtained, you would say illegally, needs to be suppressed. And then the state would have an opportunity to respond. And then the court would set a hearing to take evidence for usually if it's a suppression motion by the defense, it's actually the state that has to present evidence to show why the evidence should not be precluded. And so they'll have to put witnesses on the stand and ask them questions, have the witness testify, and then the defense gets to ask their own questions, and then both sides argue as to who's right. That's called an evidentiary hearing. Another type of hearing that you'll often hear discussed in Superior Court is a Donald hearing. There was a case back some time ago that was called Donald, where a defendant argued successfully that they never rejected a plea offer that had been made to them, and that they did not understand the plea well enough, and the state was forced to give the plea back. And so what that case created was a mechanism by which the courts ensure that when a defendant is not accepting a plea offer, that they're choosing to move forward to trial, that they're doing so knowingly, intelligently, and voluntarily, much the way they would need to be doing if they were actually entering into a plea, if they were changing their plea, which they would also have to do knowingly, intelligently, and voluntarily. And so the court might set what's called a Donald hearing to take down the record, to create the record that the defendant is in fact rejecting their plea offer knowingly, intelligently, and voluntarily. And so that's what a Donald hearing is. Not so much a hearing, but something that happens in court that gets talked about quite a bit are settlement conferences. A settlement conference is what it sounds like. It's a conference between the parties to try to settle the case, to try to reach a resolution of the case. And this is presided over by a judge, usually not the same judge assigned to the case, so that that judge can remain uninformed of the facts of the case until the opportune moment, which it would be a trial. And so if a settlement conference happens, it tends to happen in front of a different judge. And that is something that the parties are allowed to ask for, that the defense is entitled to ask for. And if a settlement conference happens, then both sides need to make sure that whoever's at the conference has the authority to negotiate for a settlement of the case. And the judges have a lot of leeway on how these conferences are conducted. I've done them where everyone stays in the courtroom and the judge is there to help just sort of mediate the conversation. I've also had it where the judges will separate the parties and they'll put the prosecutor back in chambers, which is the judge's office, and they'll leave the defense attorney with their client in the courtroom. And then the judge is going to be going back and forth, sort of like a messenger. He's going to talk to one side, get their position, and then he's going to go talk to the other side and presumably present the position in a way that's going to help reach a resolution. Settlement conferences are a mixed bag. They often don't result in any kind of compromise or settlement, but they also do, in many opportunities, lead to some kind of movement in the case. And so that is something that is often worth pursuing in a case. Let's talk about plea agreements. Plea agreements are written documents that are basically contracts between the state and the defendant specifically. And so what a plea agreement is a resolution of the case where the defendant is going to admit their guilt and waive their right to trial and spare the state the burden of proving the case beyond reasonable doubt in exchange for something, some kind of leniency. And so often it's fewer charges or reduced charges or a stipulated lower sentence. It could be that if the person were to proceed to trial, they would not be eligible for probation. They would have to receive a prison sentence, but they might get a plea agreement which puts probation on the table. Could be a number of reasons why a plea agreement is worth taking, but there also could be certainly the situation where plea agreement is not worth taking. The decision of whether or not to take a plea is the defendant's. It's not the defense attorney's. The defense attorney will counsel the defendant and provide their experience, their expertise, their take on things so that the defendant can make a proper informed decision. But ultimately, the decision is the defendant's. And so that's what a plea agreement is. And it has to contain the terms of the agreement. It also will give the defendant a warning as to all of the rights that they're giving up, including their appellate rights. It's going to lay out what are the expected and known consequences of entering into the plea agreement. It'll often mention some collateral consequences. It tends to mention that if the person is not a U.S. citizen, pleading guilty could impact their ability to remain in the country, etc. And when a person is going to accept a plea agreement, they're going to do so in what's called a change of plea. And the reason it's called a change of plea, as I've alluded to earlier, is because when they started the case, they pled not guilty, but in order to enter into the plea agreement, they have to plead guilty. So they change their plea from not guilty to guilty. And so a hearing could be set to do that, and that hearing would be called a change of plea hearing. And what happens at the hearing is that the judge is going to run through the agreement, usually not in as much detail as the defense attorney does, but they'll run through the agreement to make sure that the defendant is clear on what it is that they're agreeing to, that they understand what are the necessary consequences, but also what are the possible consequences. So the judge will advise the defendant of the minimum sentence that the person can receive under the plea agreement, but also about the maximum sentence that the person can receive under the plea agreement. And once the judge is satisfied that the defendant is entering the plea knowingly, intelligently, and voluntarily, meaning that they know what the agreement is, they understand the ins and outs of the agreement, and they're doing so of their own free will, no one's forcing or threatening them to do so, then the judge will say that they accept the plea, they enter it of record, and at that point, the person is convicted. And all this happens at a change of plea. One other kind of pleading that I haven't mentioned yet is a stipulation. A stipulation is very similar to a motion in that you're asking the court to do something, but you're doing so with the buy-in of the other side. A stipulation is an agreement between the two parties, the two sides, the state and the defense, that the court needs to do something. So if you need to move a hearing, you could file a motion to continue the hearing, asking the court to move a hearing for whatever reasons you lay out in your pleading, or you could reach out to the other side and say, hey, I really need to move this hearing. Would you guys have any objection to doing so? And if they say no, you could ask them as the defense attorney, is it all right if I file it as a stipulation and may I sign for you? And if they say yes, then you file the stipulation. And the idea is that it's not controversial. The court should not need a hearing to discuss it. The sides agree, and the court can just go ahead and order the stipulation, order the continuance of the hearing. And so that's what a stipulation is. All right. So now we're going to talk about getting into the trial process. First of all, let's talk about what a trial is. A trial is the mechanism that is designed to allow the state to seek a conviction against a person who is otherwise presumed not guilty, presumed innocent. And a trial can be either a bench trial or a jury trial. A bench trial meaning that there is no jury. The judge is going to decide the facts. They're going to decide whether or not the defendant is guilty or not guilty, and then preside over the trial as well, versus a jury trial where, although the judge is there to preside over the trial and to sort of act as the referee, calling balls and strikes. I apologize for all of my non-American viewers who don't really know baseball, but they're going to preside over it to serve as an official to make sure that both sides are playing fairly and that the process is being followed. But the decision of guilt or innocence is going to be determined by a jury, and the number of jurors depends on how much time the person is facing. So that's the difference between a bench trial and a jury trial. But the trial in general begins with, if it's a jury trial, jury selection, which is also known as voir dire. And if it's a bench trial, it's going to begin with opening statements. Once the jury is selected, the process is going to seem very similar between a bench trial and jury trial because the case begins with opening statements where each side is going to give a preview of what they think the evidence is going to be in the case. And then you move on to the state's case in chief, where they're going to put on witnesses to testify and to presumably lay out the information that they think is going to help prove their case beyond a reasonable doubt. And then the defense gets a chance to ask questions of those witnesses, what's called cross-examine those witnesses, and try to poke holes of doubt in the state's case. Once the state has presented all of its case, the state will rest, and then the defense has the opportunity to present its own evidence. And it's not often that the defense actually puts on evidence because here in the United States, a defendant has no burden of proof or of production. The defendant is entitled to argue that they are not guilty based on the fact that the state didn't prove its own case, and the defendant doesn't have to provide any evidence. But oftentimes, the defense will provide evidence. If the defense, for example, is asserting that they acted in self-defense, they're going to need to provide generally some evidence to show that. But it could be that they're arguing that someone else committed the crime, so it would present evidence of that. It could be that they're arguing that the defendant committed the crime, but they did so while they were in the throes of a mental illness or defect that made them unable to appreciate the nature of the actions that they were taking, which is called guilty except insane. And so you would present evidence of that as well. So the defense gets an opportunity to present evidence. Once the defense rests, the state has an opportunity to rebut. They can try to present additional evidence to respond to the information that the defense raised in its own case. And they may do so or they may not do so. Let's assume that they do. Then the state will rest again. And then you'll move into closing arguments where each side will get an opportunity to give a summary, a summation of what their case is and why they should win. Then the judge will give instructions to the jury on the law and explain to them how the law works so that they can determine, based off of the evidence that they had presented to them, how whether or not the state succeeded in proving its case beyond a reasonable doubt. And then the jury will go off to deliberate, and they'll do so in secret in the jury room, and no one gets to find out how that process is going. And once they have deliberated, they will generally reach a verdict. And a verdict is that determination of guilt or innocence. In a bench trial, the judge reaches the verdict. In a jury trial, the jury does. And so they need to determine if the state has succeeded in proving its case beyond a reasonable doubt. And the verdict has to be unanimous, meaning that everyone on the jury has to agree. If a jury does not agree on a verdict, then they are what's called hung. They're referred to as a hung jury, and then it's what's called a mistrial. There is no there's no finality to the case. The defendant was presumed innocent and remains presumed innocent. The presumption has not yet been overcome, and the state has the option of trying again to see if they can eke out a conviction with a retrial. And so that's when there is a failure to reach a verdict. But if the jury reaches a verdict of guilty, what they're saying is that the state has succeeded in proving its case beyond a reasonable doubt and that the presumption of innocence has been overcome. And then once the guilty verdict is rendered, the judge enters a judgment of guilt. And at that point, the person is convicted. That's the judgment. Let me back up for a second and talk about another term, which is a ruling. A ruling is a decision from the court. So if you file a motion and you're asking the court to do something, the court is going to take its action through a ruling. They're going to issue their ruling and say either, yep, I'm giving you what you want, or no, I'm not giving you what you want, and here are my reasons why. And that's called a ruling. And it doesn't have to be in writing. Throughout the course of a trial, if you've ever had the opportunity to watch a trial, or even if you've seen it on movies and television, you've seen lawyers get up and object to say, objection, hearsay, objection, leading, objection, badgering the witness, whatever it might be. When the judge decides on that objection, that's a ruling as well. Any decision by the court is called a ruling. And that objection is technically a motion. It's a verbal motion, but it's a motion. It's a motion for the judge to put an end to the thing that you're saying is objectionable. And the court can either agree, in which case they would say that the objection is sustained, or they can disagree. And they can say objection is overruled, and that's what that means. Something else that gets issued by the court in writing, but that doesn't have the same effect as an order, is a minute entry. Basically, at the end of every hearing, the court clerk will prepare a document that is a summary of what happened in court, a paper trail, if you will. And that's called a minute entry. And so often, as in regularly, as in every case, I will receive a document after every hearing letting me know here's basically what happened in the hearing. And if the court set another court date, that's going to be documented in the minute entry as well. So you might hear that phrase also, minute entry. All right, so let's move to after the trial. Let's say that the trial ends with a conviction. The jury or the judge finds that the state has succeeded in proving the defendant guilty beyond a reasonable doubt. What happens next? Well, the next hearing that's going to get set generally is a sentencing. And that's going to be where the judge, never the jury doesn't determine sentencing, only the judge does. But the judge is going to decide what kind of sentence the person should receive. And at the sentencing, both sides are going to get an opportunity to be heard and argue for the sentence that they think is appropriate. And then the judge will also give the victims an opportunity to address the court and so that they can discuss how the offense has impacted them. And they can also make their recommendation for sentencing. And then eventually, the defendant also has the opportunity to speak in court and to speak up for themselves. They don't have to, and the court's not supposed to hold it against them if they don't. But the reality is that um, judges might have opinions as to whether or not a person should take the opportunity to address them at sentencing. I had a sentencing just this last week where my client, when asked if he had anything he wanted to say, he said no, thank you. And the judge basically said, I think you might want to talk to me. This is your chance to convince me of what it is that I should do with you. And what followed was a rather lengthy conversation and back and forth between the two of them. But ultimately, the result was a good one. The sentence that my client received is the sentence that we were aiming for. But it was kind of a surprising moment for me because I'd never seen that before. I'd never seen a judge basically not so much demand that my client address them at sentencing, but really strongly encourage them to do so. Most of the time, every other time, if my clients say no, they have nothing to add, they're just going to let me do all the talking. The judges accept that, but that was a different situation, I suppose. Before you get to the sentencing, there is usually, certainly in felony cases, a pre-sentence report interview. What happens is that the probation department is tasked not only with supervising people who are on probation, but they also have to prepare reports for the judges to consider at sentencing. And so what they'll do is they'll interview the defendant after they've been convicted to talk to them about their family, their employment history, their education, their mental health, their medical history, their romantic relationships, to figure out what is this person's current situation? What is their life situation? What kind of services could they benefit from in order to keep them from getting in trouble again and to be successful on probation? That's the theory behind it. And so the probation officers will gather this information, among other places, in an interview with the defendant that the defendant is entitled to have their lawyer present for, by the way. And so that interview is conducted, and then eventually will take the information that they gathered in that interview and in other places and create what's called a pre-sentence report, or PSR, as it's commonly referred to in my field. And the judge will look at that pre-sentence report and rely on it to make their decision as to what the sentence is going to be. Among the things that a judge can order, besides prison or jail, or probation, is restitution. Restitution is money that the court can order a defendant to pay to make the victim whole again. And the theory behind restitution is precisely that. It's not that the victim's going to make money from being the victim. That's not allowed. That's what's called a windfall. And the victim's not supposed to profit from being a victim. But the theory is that the defendant should be responsible for making the victim whole again and putting them in the same position they would have been in had they not been the victim of the case, which of course is impossible, but it's what we're aiming for. So, for example, if a defendant um, drove a car into a victim's home and the victim had to repair those damages, they can submit the receipts for those repairs and demand that the defendant pay for those repairs, and that would be called restitution. I've talked about probation a bunch. Let's explain what that is. Probation is technically a suspension of sentence. If you're paying attention in court, when a judge imposes probation, they'll say that the imposition of sentence is suspended. And the idea is that instead of sending the person to prison, we're going to supervise the person out in the community, give them a bunch of conditions. To some extent, it's similar to pretrial services supervision, except it's far more rigorous, far more onerous, and the person is no longer being treated as though they're presumed innocent because they're not. They've been convicted. And so it is that if the person satisfies their probation, they don't have to go to prison. They don't have to go to jail, unless jail is a condition of probation, which is an option. But if they violate their probation, then the court can reconsider the sentence and can choose to now impose an actual prison sentence. And that's why it's called a suspended imposition of sentence. If the person successfully completes probation, then they never need to go to prison. And that's exactly what everyone's hoping for when they're placed on probation. If the person violates their probation or is deemed to have violated their probation by the probation officer who's supervising them, then the probation officer would file what's called a petition to revoke probation, or a PTR. And that document is very similar to a complaint in that it's a document that the probation officer, is filing with the court to put the court on notice that they are accusing the defendant, or probationer in this instance, of having violated their probation and seeking for the court to reconsider the decision of placing them on probation in the first place. And that's called a petition to revoke probation. Much like when it comes to a complaint or an indictment, the person is still presumed to not have violated their probation, and there is a process that needs to be followed in order for the court to be able to determine that the person has violated their probation and therefore open them up for resentencing. That process is what's called a violation hearing. Now, a defendant can admit to having violated their probation, and they can just do that through putting in an admission, or they can deny it and demand a violation hearing, which is going to be very similar to a trial in that both sides are going to be there. The state's job is to help the probation officer demonstrate that the defendant violated their probation, whereas the defense's side, their job is to try to persuade the court that there is no violation of the probation. These violation hearings are pretty rare because the burden of proof is much lower than proof beyond a reasonable doubt. The only thing the court needs to find is that by a preponderance of the evidence, the person violated their probation. And preponderance of the evidence means that it is more likely than not that they violated probation. It's a pretty low burden. And because there's a probation officer that's saying that the defendant violated their probation, it's a really uphill battle because the word of the probation officer is always going to be more valuable than the word of the defendant, unfortunately. So if it's your word against the probation officer's word, chances are you're going to be found to be in violation. And then the court's likely to treat you more harshly for having gone through the violation hearing rather than admitting to your mistake. And so there is a strong pressure for a probation officer to make the admission to having violated their probation. And if they do, then the judge has all of the same sentencing options that they had originally when they first placed the person on probation. They could sentence the person to jail. They could sentence the person to prison. They could put the person back on probation with increased conditions of probation. Um, it could be the whole gamut. So you don't want to have a petition to revoke probation filed against you if you're on probation. It's not a good thing. But if you do, you definitely want to have a lawyer help you deal with that situation. Another acronym that I did not mention earlier, but I should have, is PTS, which stands for pretrial services. So you might see in writing, I don't hear a lot of people say PTS. in open court, but you'll see it in writing quite a bit because it's shorter to type than pretrial services. And that's what it's referring to. PTS is pretrial services. Another acronym that is very common to see is DOC, Department of Corrections. Again, it's a lot faster to type DOC than Department of Corrections, and it's also a lot faster to say. So you will hear people say he's being committed to DOC for X number of years. And that's what that stands for. Department of Corrections is the government agency that oversees the prisons. So if you're committed to the Department of Corrections, you're being sent to prison. And that's what that is. Anyway, I know that was long, but that was fairly comprehensive. If you've stuck with me this whole time, you now have a pretty decent understanding of the various terms and phrases that are used in our Arizona courts. And I hope that having that knowledge arms you to be better informed and more confident navigating what is otherwise a rather complicated and scary system. Remember, you have rights. They matter. Protect them. Stay safe. If you need the help of a criminal defense attorney here in Arizona, please give me a call. You can either reach out to me at this phone number or you can go to my website, chornylaw.com, spelled my last name, LAW.com, and give us a call. We'd love to help. But in the meantime, like I said, stay safe, and I'll see you in the next video.